everyone, welcome to Lecture 1 of the Data Privacy Act lecture series entitled Personal versus Sensitive Personal Information and Scope. Section 7, Article 3 of the 1987 Constitution grants the right of the people to information on matters of public concern. Personal matters are exempt or outside the coverage of the people's right to information on matters of public concern. The right to informational privacy has the following aspects: to keep inalienable information to themselves, to prevent first disclosure, to prevent further dissemination in case the information has already been disclosed, and the right to be forgotten, or the right to prevent the storage of data. Section 2 of the Data Privacy Act, or DPA, provides that it is the policy of the state to protect the fundamental human right of privacy, of communication, while ensuring free flow of information to promote innovation and growth. The state recognizes the vital role of information and communications technology in nation building and its inherent obligation to ensure that personal information in information and communication systems in the government and in the private sector are secured and protected. Thus, the twofold purpose of the DPA are as follows: to protect the right of privacy and the right of communication, and to ensure the free flow of information to promote innovation and growth. The challenge for the state is to strike a balance between the two purposes such that each is accomplished without compromising the other. The Data Privacy Act of 2012 applies to the processing of all types of personal information or data. Personal information refers to any information, whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information, or when put together with other information, would directly and certainly identify an individual. The kinds of personal information are as follows. First, ordinary personal information such as individual's name, date of birth, IP addresses, among others. And secondly, sensitive information such as race, age, color, marital status, religious affiliations, among others. And finally, privileged information such as conversations between husband and wife, attorney and client, priest and penitent, among others. As a general rule, the processing of sensitive and privileged information is prohibited. Data pertaining to juridical persons such as corporate name, addresses, and financial information are not considered personal data and hence do not fall within the scope of the DPA. Thus, the disclosure or processing of a company's financial information fall outside the scope of the DPA. Take note also that Section 17 of the DPA specifically grants the lawful heirs and assigns of the data subject the right to invoke the rights of the data subject at any time after death or when the data subject is incapacitated or incapable of exercising his or her rights. Hence, when personal data of deceased individuals are processed, they are still considered as data subjects and lawful heirs and assigns may exercise the rights of the deceased as a data subject. Also take note that anonymous information is not subject to the requirements of the DPA. Information is anonymous when such information does not relate to an identified or identifiable natural person or to personal data rendered anonymous in such a manner that the data is no longer identifiable. Finally, take note also that DPA is still applicable even if the personal information is available in the public domain. Now let's talk about the scope of application of the DPA. Those who process personal data or are involved in personal information processing, whether natural or juridical persons in both the government and private sectors, are covered by the DPA. The DPA covers personal information controllers and processors. Data subject is an individual whose personal information is processed. A data subject is therefore a natural person whose personal, sensitive, and privileged information are entitled to protection. A personal information controller is a person or organization who controls the collection, holding, processing, or use of personal information, including a person or organization who instructs another person or organization to collect, hold, process, use, transfer, or disclose personal information on his or her behalf. There is control if the natural person or juridical person or any other body decides on what is collected or the purpose or extent of its processing. The Personal Information Controller, or the PIC, is accountable for complying with the requirements of the TPA and shall use contractual or other reasonable means to provide a comparable level of protection while information are being processed by a third party. The Personal Information Controller is expected to be responsible for any personal data under its custody, including the processing of information that have been outsourced to a personal information processor by the use of contractual or other reasonable means. With this, the personal information processor may still be held contractually liable to the personal information controller for violations of their agreement. The PIC shall designate an individual or individuals who are accountable for the organization's compliance with the TPA. So that's it for today's lecture. Thank you so much for listening.